Okay, let's tell you about the Senzo Meyiwa murder trial. It has gotten off to a slow start today with a cross-examination of Magistrate Vivian Cronje pushed to 2 p.m. this afternoon. This is to allow the defense time to consult with their clients and to also listen to the audio recording of the pro forma. Today, just like yesterday, is focusing on accused number 2, Bongai Ntanzi's alleged confession. We speak to legal analyst Nthabiseng Dubazana for this and more. Thank you very much for your time this afternoon. Perhaps let's revisit this moment just yesterday when the defense was disputing the alleged confession that was made by accused number 2 in the trial within the trial.
Yes, so I beg your pardon. The main issues that we're dealing with here is that the accused is saying that they never actually gave this confession in terms of section 218 and 219. That's basically the gist of why this trial was conducted. So the purpose of the magistrate coming in to give this evidence is to show that indeed the accused, one, did reduce the confession into writing in front of an officer of the court, and also that it was in accordance with section 218. And part of the evidence that she was giving yesterday, as she was reading out the paperwork or the pro forma, as so it's called, when conducting this interview with the accused, was to ensure that, one, the accused is doing this confession freely and voluntarily without any undue influence, and that they were in their sound and sober senses. Part of the questions there, if you remember, was whether or not he had been hit or physically abused in any manner or form, if there are any body markings that show that he's been abused, and he confirmed or allegedly confirmed that he had previous markings on his body from other things and not particularly being forced to make the confession that it's alleged he made.
In fact, let's revisit that moment and hear from the magistrate.
It was noted that the deponent is confident, made good direct eye contact. He wore a blue medical face mask, long sleeve navy blue, light blue front top, Impala emblem, track suit jacket and a blue denim. Both his hands were cuffed in front of him.
Just in het oomblikie. Dan is die gedeelte wat my gelede vriend versoek het dat dit nie op record geplaas moet word.
That's now just a moment. That's the part that my colleague requested not to be placed on record.
Okay, kan voortgaan, excuse.
Both hands cuffed in front of him, cuffs loose, not tight.
As you rightfully mentioned, she went on to give testimony that she asked whether at the time when he was making the confession statement, allegedly, whether he was coerced, whether he was abused, whether anyone had exerted pressure on him, to all of which he said no. What should we understand about that? Because it is also alleged that he was there and he was represented by an attorney, yet the defense is arguing that, well, he made the confession statement under duress.
Unless the state is willing to have that attorney be subpoenaed and give evidence to confirm that indeed he or she was indeed the attorney of record at the moment that this confession was made, there is no other evidence apart from what the magistrate has said, and also apart from the video evidence that is currently being viewed by the defense attorneys. If you recall from yesterday's proceedings, Advocate Mshololo had objected to the witness giving evidence that comes from the video recording, because the defense attorneys had not been privy to this recording, and at some stage the state had also said that they're not intending on using this recording, because if you remember, a lot of the parts of the statement were retracted, and therefore because they're retracted, the video evidence won't be used, because all the parts that were retracted in the statement will obviously come to light in the video. And then tomorrow, I beg your pardon, today, it was a change of tune, wherein the state is saying, listen, we are intending on using this video after all. Whereas yesterday we said we are not going to use it, and now the defense is now ambushed with this evidence. The main problem that I have with the way that this situation is being dealt with, it brings back the memories of when this matter was first heard in front of a different presiding officer, and the first docket, or the second docket, I beg your pardon, was not disclosed to the defense attorneys, and we had to have a situation where the attorneys have to now first go through the first docket, get instructions. We are now back there again here, and the presiding officer wanted to be present when the accused and their defense attorneys are watching this thing for the first time and getting instructions, which is irregular. And then only when it was made clear to the presiding officer that we're not leading evidence, we are trying to get instructions because this has never come before us before, only then did he realize what the attorneys are trying to say, which is very surprising for me.
In fact, let's revisit that moment.
So in essence, when when the audio is played in the presence of the gentlemen who are before court as accused and their legal representatives, that is basically a consultation, is it not?
As the court pleases, my lord, it is, my lord.
It is?
Yes.
Yeah.
That's what we are asking.
No, just wait. So a court can't sit in a consultation.
Yes.
Is that so?
Yes.
Yeah, fine. I'll go and read up what would be the other option. So I will excuse myself. You listen to the audio regarding the pro forma. Is that not so?
Yes.
And then subsequently you also want to listen to the...
No, only the pro forma at this stage, my lord.
Yeah, but the point is, some people here haven't listened to the statement itself on the audio.
Yes, but...
Like Mr. Ngumal, am I right, sir?
Yes, but
so what do we do about that?
That is the bridge that we will cross some times in the future. I mean, if the court rules that the statement is inadmissible, then...
No, I can't rule before everybody has listened to the tape.
Yeah, then the contents become irrelevant. All we're saying is that at this stage it's only about the prerequisites, my lord, that we mentioned.
Right.
And that the statement will only become relevant should the court rule that the prerequisites have been met. So if the court rules that they haven't been met,
of course it's irrelevant.
They need to listen to the statement falls away.
Do you agree about the legal... Mr. Ngumezulu, do you agree about that true agreement? Even you, Mr. Ngumal?
Yes.
Mr. Solot?
I agree.
Yeah, okay, fine. It shall so be done.
Nthabiseng Dubazana, very quickly, what is a pro forma? And you also mentioned the irregularities on the part of the state. Does it appear to you, though, that the defense, or rather, what is the defense of the defense, even when new information pops up or the state says we're not intending to use this but comes back and changes the story?
So to answer your question, a pro forma is basically a guideline that is given. It's used as a standard form that the magistrates would look at in terms of dealing with a confession. That's why in the beginning of her evidence, the magistrate said that this is what the Boksburg Magistrate Court would use when dealing with a Section 218, Section 219 confession. So that's basically what it is, a standard form that is used by the magistrates in that particular court. So the defense, what they did today was correct in saying that we are being ambushed. I feel, unfortunately, maybe I'm speaking from a point as a defense attorney, but I feel as if the presiding officer puts the cart before the horse without hearing the applications of the defense attorneys and assuming what it is that they're going to say. And only when one or more people have said the same thing, only then does he sit back and try and understand what the initial application was. It's not the first time that I see this happen throughout this matter. And then he puts the cart before the horse, and then all of a sudden things don't work out the way that he had anticipated. For example, him drafting a judgment before an application was actually made before him, which doesn't make sense. I feel like the presiding officer needs to give the attorneys that are before him an opportunity to speak and give what the application is, and not give judgment or decisions on any application before he's had the full arguments before him.
Nthabiseng, we've seen, though, the judge on numerous occasions citing case law, more so when it comes to certain situations, I guess, if not all the time, where he's just like, I don't want people to say it's this judge. I don't want people to say it's Rata that is doing this. He's always citing the law. He's always emphasizing and stressing whether something has been done legally or whether it applies legally. Has the law been followed? We hear that a lot.
Be that as it may, case law is there that he cites. I agree with you fully. But in the manner in which he interprets or applies a certain case law, I sometimes differ with what he says. For example, there was an application that was made. It escapes my mind. It was when it comes to the witness and claiming the right of not incriminating themselves, right? In the manner in which he applied that, he claimed that right for the witness before the witness could claim that. What the section actually says in the commentary on that, as well as case law from the appellate division for that matter. The appellate division was what we now know as the SCA. So what the courts had said at that time had said that the court is obliged to inform the witness of what is the possibility of you answering this question if it will end up incriminating you in a further legal procedure that may follow that involves you alone, and not particularly in this case. Okay. It was a necessity for you to inform the person. But what the judge did here was say the witness will not answer this question because it is incriminating. That was already claiming the right on behalf of the witness, instead of saying, listen, this question, in my opinion, will lead to this. Okay. Please be aware that should you answer it, this is the consequence. So the witness can claim that right before the judge claimed it for him.
Nthabiseng Dubazana, thank you very much, ma'am, for your time this afternoon.